In the interest of making sure we have enough time for our speakers, I'm just going to revert to a short introduction of our moderator and our panelists. Everybody's complete bios are in our beautiful packet here, so if you want to know more about our amazing speakers, please refer to their bios in the packet. It's my pleasure to introduce my amazing colleague, Tara Righetti, who's going to moderate this panel. Tara is a UW School of Energy Resources Professor of Law and the Occidental Chair of Energy and Environmental Policy. So you're in good hands with Tara as moderator of the panel. So Tara, I'll turn it over to you.
All right, thanks everyone for being here. And thank you again to Holly and Temple and Christine and everyone who put on this wonderful event, which is one of the things I look forward to all year. I'm really pleased to be able to introduce this panel on the spent nuclear fuel and to introduce our wonderful panelists. And I think this is such an important topic to discuss right now because there's so much happening right now in the nuclear sector. And this is a topic that's on everybody's mind and always comes sort of to the top of any conversation about nuclear is what is the plan and what do we intend to do with spent fuel. And so we have a wonderful group of experts to speak on that today. I want to start with the caveat that we're not having this conversation here because anybody has proposed putting any of these projects in Wyoming. It's more because it's an issue of national scale that is really important as we evaluate how to move forward with these projects to provide some of the power that we heard about needing this morning to fuel economic development growth and to add more clean energy into our system. So to begin with, we have Stewart Forbes, who's sitting here. Stewart is counsel at Hogan Lovells, but was formerly with the Department of Energy, and that's how I got to know him through his work with the Advanced Reactor Demonstration Program and learning more about how DOE is supporting commercialization of these technologies. Next to him is Scarlett Forrest, who's an assistant research scientist in my research group, Joule, and we are just thrilled to have her join us and comes from not only having her JD at UW, but also a history before that working in environmental management. And then we have Bud Haemer, who is a senior fellow and Nuclear Council, American Electric Power, also a professor at GW, and an expert in a lot of these different practices. So you can see their whole bios there. And then we're going to have presentations of about 20 minutes apiece. Our fourth panelist, Marla Morales, who is with DOE Consent-Based Siting, was unfortunately not able to join us at the last minute due to the shutdown. So everyone's going to talk for about 20 minutes, and then I have some prepared questions, and we'll also open the floor to questions from all of you. So thank you.
I got it. Just for the record, that was not me. Are you getting me? Okay, good. So I'd like to, there's a lot, I prepare too much. This is the classic lawyer problem. We don't know how to stop talking, but I'm gonna try to keep it within the 20 minutes. I did have a few things to bring up though. First off, my father-in-law made me promise that when a DC lawyer comes to Laramie that I point out that he is from Evanston, okay? So there are Wyoming ties here. And I spent 5 years in your neighbor to the west state serving the Department of Energy at the Idaho National Laboratory. So in working on the Natrium project out in Haemer, like I am familiar with Wyoming and so grateful to be here. Also, Buffalo Bills fan, so Josh Allen, thank you guys. All right, so that's the intro. The rules that I violated, these slides are gonna be ridiculously wordy, and I'm sorry. I know that's not what you should do. Again, a lawyer, we like to talk. What is going on right now in advanced reactor space is really, it's the final eruption of pressure that has been building for the last decade. As long as I've been in this industry, We have been looking at new types of reactors, new types of technology. The government has been supporting it, industry's been promoting it, but it has gone exponentially, it's just exploded, and especially within the last year, and under Trump too, we are seeing things that we really I never expected, having worked in this industry for a while now. So much so that these slides, which I finalized on Tuesday, are already out of date because there is a significant announcement by the Department of Defense this week that they will be putting forward 8 new advanced reactors to power DoD bases across the country under DoD authorities in partnership with the Department of Energy. Sorry, DOW authorities. That's hard. Department of War authorities. That's a recent change. Like I said, everything's changing. So to go to this topic, though, we have to really go back to the beginning. And what we are looking at right now, with the question of spent nuclear fuel, you have to look at what are the reactors and how do reactor operations and fuel management, because spent nuclear fuel, again, that's the back end process. I'll use coal since we're in coal country. You put uranium in a reactor, the physics work out, it burns. What you have left instead of fly ash is spent nuclear fuel. There, that's the idiot's version of nuclear technology. Under the Atomic Energy Act, which was passed in 1954, any person in the country who wants to and the words are funny because this is the 50s, manufacture, produce, transfer, acquire, possess, use any utilization or production facility, basically means run a nuclear reactor, has to have a license issued by the commission. The commission in this case was the Atomic Energy Commission. 1974, that changed, became the Nuclear Regulatory Commission. In addition, if you are a reactor operator, you have to have a contract with the US Department of Energy to take back that waste product, that spent nuclear fuel. This was added in 1983 under the Nuclear Waste Policy Act. It's the advanced contracting requirement. So any entity, any company, be it TerraPower and Kimmer, to NuScale out in Idaho, back when that project was under development, any company, and the Vogtle units in Georgia, before they can operate, they need that license with DOE, that contract with DOE rather, in order to get the license from the NRC. Well, that begs a question that's really interesting here because, and when I asked my 11-year-old this question, he looked at me like I was crazy and only a lawyer would ask it. What is a person? Well, the answer is on the board. Person is, and I'll let you read it. It boils down to everyone. Everyone is a person. Because what happened in 1954, prior to 54, the government had a monopoly on nuclear technology. The 1946 Atomic Energy Act created this government monopoly. By 54, we had realized there were private sector uses. Power was growing. We demonstrated the ability to light a light bulb with the experimental breeder reactor 1 out in Idaho. And we started looking at the privatization of this fuel, of this energy technology. And so Congress, to encourage it, said, yeah, we will open this up to the private sector, but you have to have a license. The only entity, the only legal non-person, now there's your CLE credits for the lawyers in the room. Your only legal non-person is the commission, and its successors, the Department of Energy and the Nuclear Regulatory Commission. So under law, the Department of Energy can build a reactor without a license. It operates on your borders out at the Idaho National Lab. 4 with the 5th coming online soon. It operates a reactor in Tennessee. These aren't NRC regulated reactors. However, Congress in 1974 said, well, when we set up what became the Department of Energy, we don't want you to bypass the licensing requirements that the NRC, we have required the industry to have imposed upon it by the NRC. So if you, Department of Energy and Congress, get the bright idea of putting power on grid through one of your reactors, we're gonna still make you go to the NRC. It's a weird thing. It happened in the Energy Reorg Act of 74. It really hasn't been an issue because up till now, the department was really keen, really had a research focus. They were not interested in putting on their own power. And if they were, it was usually through like the Bonneville Power in the Pacific Northwest. This is a utility. I believe at one time they operated the Columbia River Generating Station. Fine. It's NRC license, not a big deal. Now, I'm going to pause here because one thing that I would have put on this slide had I known Tuesday what happened, but I didn't, is the Department of Defense is also similarly situated to the Department of Energy. It can own, operate nuclear reactors for power, for commercial, for manufacturing, for process heat, if the president so directs it, or so directs the Secretary of Energy to authorize them to do so. Well, there is a standing authorization dating back to the 80s under the Reagan administration. And in the executive orders that we'll talk about in a second, President Trump has said to start looking at these authorities. DOD announced on Tuesday the 9 reactors that I mentioned earlier. And this is also how the Project Pele, which is being built in Idaho, is being done. So I mentioned the reactors that we've seen. From 77 to 25, basically DOE operated these 5 that are on the list. Marvel is coming online. And when DOE intersected with grid scale, with commercial reactors, it was for things like supporting licensing. This is the Interim project. This is the XE100 project in Texas. This is the Kairos project in Tennessee. Additionally, the Small Modular Reactor Licensing Technical Support Program was NuScale and Utah Associated Municipal Power Systems in Idaho, Empower, and TVA in Tennessee. It was pretty clear. You had your mission to test materials, to perform science experiments. Those are done in the DOE reactors. And when Congress told them to, they would give money over to these companies to build commercial scale reactors that would be NRC licensed. Well, all of that has kind of been turned on its head a little bit. And what we've seen in 2 pertinent executive orders, building off of what our prior speaker was talking about with the Unleashing American Energy, in May of this year, President Trump issued 4 nuclear executive orders. I'm citing one here because it was the one that I thought would be the most important, but the other executive order 14299 calls for the Department of Defense to build nuclear reactors. So within executive order 14301, however, President Trump did a few very interesting things. If we go back to the slide, to language I put online on the screen earlier in the energy reorg, DOE would be subject to NRC licensure if they built power reactors or if they built a commercial scale reactor. Well, President Trump said here that the reactors that he is calling to be built are perforce not for the purpose of demonstrating the suitability of commercial application of a reactor. And the logic is sound. We haven't built these. They're not commercial yet. They're in development. A lot of them are prototyping. And then for the foreseeable future, at least, we know that these aren't going to be, these first of a kinds are probably not going to be of a type to put power on grid. So DOE's authority is okay to use. In addition, and this is novel, the administration has instructed the department to put these developers under contract with DOE. Because remember, we started talking about persons. They would be persons normally for licensure. Now they're not. Now if they go under contract with DOE, DOE is the entity who's developing the project. And so this is what we have seen happen, is that it unlocks a new paradigm really of development legally. And for the contract lawyers in the room, this is going to hurt your brain a little bit. And I've tried to figure out, we have the triad of offer, acceptance, and consideration. I don't know how this works, but the structure here is that the department is using, and the Department of Defense, Department of War, are using this contractual structure called other transaction agreements. It allows for DOE and DOD to exercise their authority on $0 contracts. They're not offering anything as far as money goes to developers who will come and take advantage of the regulatory authority, the licensing authority of the 2 agencies to build these reactors out. So I assume that when you break this down, the offer is the authority and the acceptance is, yeah, we'll take it and build our reactor. I don't know. We'll do that in contracts law for the 1Ls next year. But as a result of this program, you now have 11 selected DOE advanced reactors that are being built under contract. Now, these are spread all over the country, at least from the press reports I know. We have Idaho, we have Texas, I believe we have Tennessee, all involved. And the DOD reactors, DOW reactors, are going to be built at bases to be named later. Now we're going to get to fuel. Sorry, that was a long buildup, and I probably ate all my time, but we're going to get to fuel here. Because these reactors use different fuel matrices than what we had seen in the past. In 1983, Congress passed the Nuclear Waste Policy Act. This act did a few things. It required the establishment of Yucca Mountain. We'll get to that in a second, that we all know about it. It required DOE to take back spent nuclear fuel and high-level waste. And it required DOE to set a standard contract with which it would enter into agreement with the developers for the take-back of this fuel. Now, it's interesting here because this was set at a time when the reactors that were in operation were all largely the same. They were all light water reactors. They were all operating on a very similar fuel matrix, usually uranium oxide fuel. They were operating at a lower enrichment than the advanced reactor community does. And so they became what is known in the standard contract as standard fuel. This is the standard fuel form that the Department of Energy used to define the waste acceptance at Yucca Mountain. It is very clear, and you can see the table and down there in the bottom right. These are the types of fuels that are standard. Now, these are not advanced reactor fuels. And under regulation, there is this notion that, yeah, the department will also take non-standard materials, but there will be more considerations. You'll have to think about your thermal energy output. You'll have to think about your casks. If it has things like a novel sodium bond to the fuel, you'll have to treat it. If it's salt, you'll have to figure out the casking. There's a lot more requirements of these. Most of the advanced reactor developers out there use these non-standard fuels. So what does that mean? Well, a couple things are interesting. And one of the reasons I wanted to start with talking about who is authorizing these new reactors. By law, DOE doesn't enter into NRC licenses generally, and it doesn't enter into standard contract licenses with itself for the take-back of fuel. Maybe it could, but it hasn't yet. And so these reactors that are being powered are a little bit outside of the normal scope. And it also means that these developers for these 11 reactor projects that are being built under the executive order are not required to enter into the standard contract at all. DOE will have to figure out how to take the fuel back because, as we started under the Atomic Energy Act, you can't possess nuclear material or a nuclear reactor without a license or DOE authorization. Well, what happens in the event that DOE pulls the contract, that their agreement, for whatever reason, they terminate? Well, then you have orphaned spent nuclear fuel, potentially. It's not something that we want by law, but it's something that we have not yet addressed regulatorily or statutorily. So, and then there's going back, to this, the fact that the fuels that these reactor developers are using are not standard. They require more treatment, more conditioning, more care in their storage. And well, it doesn't matter at this point because Yucca Mountain isn't operational. It may at some point. And if Yucca were to become operational, we would probably have to amend the waste acceptance criteria in order to make it so. So this is all to say that there are some big difficulties that face this moment on the fuel side, and it's something that needs to be contemplated. It's not insurmountable. These are largely the engineers and the regulators need to talk and need to figure out how to structure their contracts, because you'll have to have the contract, and structure the siting, because ultimately Congress needs to address the Nuclear Waste Policy Act. It is, in my opinion, speaking for myself, failed policy at this stage. They need to figure out what that acceptance of the fuel and what the treatment of the fuel would look like. And I will add here, since I am at time, that one of the interesting things, though, that we have at this moment is that Yucca advanced reactors lend themselves to different policy decisions. They lend themselves to recycling. They lend themselves to what we call a closed fuel cycle in the industry. And they lend themselves to lower risk, at least that's the premise of the argument for the developers, to those who want to build them. So these are some important considerations, and it's something that we need to look at because we're going to see more of these. That's clear. But the back end of the fuel cycle just cannot be forgotten in the process. So with that, Scarlett, you don't need to see me.
But you're next.
Oh.
So even though you're not sitting in order.
Sorry, we sat out of order.
Which is all my fault. What happened to don't I have my first slide? Oh, by the way, somebody killed my first slide. Okay, well, I had a nice first slide. I had a nice second slide. I had slides. These are not them. And that's not my picture. So if you're confused by it, that's Larry Brown, who taught the course before me. And I think he's very handsome, and so I'm happy to have his picture in place of me. But if you'd like to know Larry's background, which is far more interesting than mine, I'm happy to also go over that. I do know Larry, but if you're confused, that is not my picture. And if we ever find my slides, I will say that as a law professor, that they are not meant for the audience to read. They are solely for the ABA auditors who come in to make sure that we've taught some law to the student. So don't feel too bad about it. But anyway, the first slide that you're not seeing is a picture of the Atomic Energy Commission facilities as they existed in the early 50s and 60s. And there are several in Wyoming, a number in Colorado. They are fascinating as to the scope of it, but from a lawyer's perspective, they reflect a unified executive authority. One, we were fighting World War II, then we were fighting the Cold War. We had this idea that the federal government, with their technocrats, were going to properly manage this technology. And it spreads over the country under a federal initiative, leaving open the question: what was the roles of the states, other than I guess to say yes. So, and then we're working on slides. All right. Well, the second slide would show you a copy of Appendix F to Part 50. That was written in the 1980s, so it's like 45 years old. When we come back for the NEPA panel, when I worked for the Department of Energy, I had a mug that the Department of Energy gave me that was NEPA at 25, the need for reform. So I didn't bring that mug with me, but you know, I think we'll reiterate at the end of the day the same principle exists, but the mug has outlasted NEPA form. The need for, I found it when going through my office stuff. So it's the same principle. It's 45 years. It's probably time to reform Appendix F of Part 50. What happened in between when Appendix F was issued was something called NEPA. And there was the GESMO, which is the generic environmental study of, oh, look, here's my slides. Fantastic. All right, that was the first slide, in which I told you, don't read the rest of the slides. This is the only one that was meant for people to look at. Okay, there you go. There's your. I don't know why the Department of Energy, in making this picture, put a giant gap in the middle of the U.S. Imagine that it's combined. We really haven't split the nation in the middle down there. It's not even split along the Mississippi River. So, you know, anyway. But thanks, DOE, for that fascinating slide. But you can see in there the number of facilities that were built out here in the West without, let's be honest, regional consent. So anyway, there you go. You can find Appendix F. It was issued in the 80s. It codifies the 1970 Atomic Energy Commission policy and reflects, again, a federal solution to a national problem. And I like the within 10 years solidified and placed in a repository. We've certainly been complying with that one. All right. And like I said, where I was going with this is that this all unravels under the pressure of NEPA, the generic environmental study for mixed oxide and an associated legislative hearing before what started out to be the AEC and then grew to the NRC over time, pretty much resulted in President Carter gets credit for it. It started under President Ford. He paused it primarily for the fact that it was getting too hard. They were spending a lot of money and it was getting too hard to see where the light was going at the end of the tunnel. And then Carter came in and said that was an onrushing train, so we're just going to stop it. But fortunately, but it is bipartisan by the executives to realize that NEPA, with the whole failure of confidence in the federal executive, you can cite Watergate, you can cite all the other things that had gone on. Certainly 3 Mile Island Unit 2 accident didn't result in a lot of people saying, yes, this bureaucratic solution of having experts solve these problems and properly manage them really came under challenge under a number of those events in the end of the 1970s. So all of this is where reprocessing ends, to be honest. Wow, now what am I doing wrong? I pushed it at Stewart. Okay, great. Stewart is in charge. All right, and so there was a lot of contracting efforts going on before that. We can go endlessly on contract law if we want. Government contract law is different than ordinary contract law. So if you want to do any of those great things that Stewart was mentioning, do talk to somebody who knows something about government contracting. OTA is just one of the many 3-letter acronyms. You can have 5-letter acronyms. You can have other 3-letter acronyms. The Department of Energy and other federal agencies have numerous ways of great acronyms that do tremendously different things, depending on what you're trying to do. GAIN is a nice 4-letter acronym. If you're into 4-letter words, GAIN is a good one. So somebody from INL here, right in the back, ask him. He will help you hook you up with GAIN. Anyway, so like I said, this is the failures. West Valley in New York, it has its own act if you want to know about it and want to read about it. Barnwell is endless, it kicks off endless litigation. I do like the quote. You feel free to read that. I do like that one. Morris, Illinois is yet another failed facility. And the ones I don't have on here is there were a number of projects planned for Connecticut. Connecticut was a state that really felt prior to the 1970s that it was going to embrace nuclear power, warts and all. The electric boat facility there was going to be the one that builds all of the nuclear powered submarines. It was going to be a great industrial center. They had Haddam Neck, Connecticut Yankee, Millstone. There was plans to build a fuel facility. There were a fabrication facility. There were plans to build a reprocessing facility. Warts and all, Connecticut was going to become the center for that. And that's not necessarily a private initiative. I mean, the state was all in on that. But anyway, if you haven't noticed, Connecticut its nuclear power plants are shut down. Half of the nuclear work at Electric Boat is done in Virginia. I mean, it's just not been the sort of leadership that Connecticut originally envisioned. And certainly when you go on, and we'll come back to this, but there's the MOX facility in South Carolina that was originally going to be profitable when it was originally proposed by the US government and then was canceled because it was too expensive to finish. And then we can talk about all the new projects that I won't go over because Stewart did a great job at this. And yeah, it does work when I point at him. All right, in addition to, the failure of the reprocessing plants, essentially the decision by first Ford to pause the licensing and then Carter to pretty much suspend it. And then Ronald Reagan issued an executive order that everybody ignored. I haven't noticed it if people have noticed, there's sort of a pattern. The presidents issue executive orders and then nobody pays any attention to them because they don't have the force of law and can't be enforced. But that's sort of why people pay lawyers to help them deal with the law as opposed to whatever the executive decides to say. But anyway, so with all of that, Barnwell kicks off about 10 years of litigation, which, if you want to follow along in my book, starts on page 60. And it's always great when you're writing a law textbook to be able to quote pages and pages of the great Judge Posner and his resolution of this very complicated contract law case involving Allied General and several utilities, mostly Commonwealth Edison of Illinois. So, which is why even though he's a appellate judge, he was sitting as in designation on this district court case because the district court could just simply not handle the 10 years of litigation. So it's it's just great. I couldn't resist not quoting him for 5 pages in my text. But it's a huge amount of litigation when you're in the middle of doing this as a commercial entity and the United States government under the authority of the executive says, we're not going to do it anymore. You can sue the executive and apparently he won't listen to what you did. And the courts would say, yeah, he's the executive. He's got, he's using his Article 2 power. And you don't get estoppel against the government. I don't care what they promised you. I don't care what they said they were going to do about licensing. You're out $170 million. Thank you for playing. Which, to be honest, back in the 80s was a lot of money. I know today, it doesn't feel that way. But anyway, there's your Westinghouse fuel fabrication site that you can look up. Like I said, don't feel obligated to do this. This is solely put here so that it's there for the ABA people who audit us. So with that, with Barnwell, where are we today? Stewart mentioned TRISO. I won't try and tell you what it's an acronym for because I can't. It's just a mathematical term. You have to be like into three-dimensional geometry in order to understand what TRISO stands for. But trust me, it is a great acronym. It's been around since the 60s. DOE needs to bring some back from Germany. We promised that we would take back the TRISO fuel that they've been using. And not surprisingly, the Germans are still in the mode of not wanting their nuclear fuel and wanting people to take it back. So at some point, that TRISO fuel will have to come back from Germany, which will increase the amount we have in storage. The point about TRISO is that nobody knows how to reprocess it. That's part of its design. That was one of its selling features. It was supposed to help with non-proliferation concerns, which is why you can ship it to people like Germany in the 70s and 60s when people were still kind of worried. I don't know if you remember, but 1945, there was this whole war thing with Germany. We were not really, we didn't have that long-standing allyship with them that, they were allies under NATO, but that was still kind of questionable back then. I know it's ancient history. But anyway, the idea is that you could send them TRISO fuel because there's really no way of effectively reprocessing it. And so TRISO, while it is not suitable under DOE rules for acceptance under the standard contract, it's been designed to be disposable ready. You can't reprocess it. It is suitable essentially for putting in some place. I don't know if you necessarily want to store it long-term on the surface, but somebody would have to study that. But certainly it's not in a form that you want to necessarily change before you put it in the ground. I put Radiant up there. BWXT is obviously also thinking of building a fuel factory for TRISO. The flip side on that is the other, and so this is one of the things you've got to think about when you start talking about nuclear fuel. The TerraPower metallic fuel is sodium bonded fuel. In the 1990s, under their NEPA evaluation, the Department of Energy evaluated their sodium bonded TRISO fuel, not sodium bonded metallic fuel, and agreed with the state of Idaho that it needed to be processed, and so it has been, and at INL. So at least they have the technology, and you know how to deal with it. You still have the calcined high-level waste from reprocessing of the fuel, and that part of the problem hasn't been. I don't know if it's a problem. Opportunity for solution, right? Opportunity for success, opportunity to succeed. We don't have problems in the nuclear industry. We just have opportunities. So like I said, and then on Monday, there was the announcement that, which is why this slide is out of date, the Radiant is going to do that, but it's not going to do that in Wyoming. The Wyoming part, Radiant is still going to do it, just not involving Wyoming. And that's sort of the question that one has to stretch and think about. Do I have one more slide, or is this it? This is oh, I got pointed. Ooh, I don't know if I have one. No, I don't have one more slide. This was my last slide. Good, my last slide. We've reached the end. I can turn it over to Scarlett. I will just say that as a lawyer, when you look out at the current spent fuel dilemma or opportunity for success, as a lawyer, it's not hard to understand the problem. We have a bifurcated sovereign system in the United States, federalism, if you studied law school. And we have a federal government of limited power created by a constitution. Spent fuel, though, is a national problem. So you really have two methods for dealing with that bifurcated sovereignty. One, you can ask a state to give up its sovereignty. Trying to force a state to give up its sovereignty has not really worked well with Nevada. And not surprisingly, most states feel sympathy for that because it may be a triangular shaped state that you're going after the sovereignty of today, and maybe a rectangular shaped one tomorrow. So they tend to hang together on this idea of a limited federal government, and forcing people to give up their state. Forcing states to give up their sovereignty is not terribly popular. But if you could get one to volunteer to do it, you could double down, to use a blackjack. I guess I'm not too. You guys have gambling in Wyoming, but anyway. To use a Nevada type term, you could play blackjack, you could double down, and you could say, well, we're going to create a federal program and we're going to go back to that system. Or you can do something as a regional opportunity and look at that. So those are your, oh, look, I have slides. Where'd they come from? And the point, and just the point on these are the questions that are paused, but the big fundamental two questions are, do you want to go with the existing strategy that you started in the 50s of one federal executive? Do you want to go back to that? Do you want to just have that concept? And all you need to do that is have at least one state be willing to let the federal government have sovereignty over all of the other aspects that a state normally does in that area. Or do you want to have a combination between a state and the federal government in sort of a public-private partnership of all three being involved together? Or if you want to throw an Indian tribe in there, three sovereigns and private entities all in there. Room for regional cooperation, right? I mean, your Natrium is going to have fuel here in Wyoming and perhaps some other states that is suitable for reprocessing in Idaho, which at least the INL has the technology. I mean, there's giant holes, probably holes here in Wyoming that you could put that stuff in. There's certainly one that's been dug in Nevada and Yucca Mountain. So there's room for like a regional solution to say this can be resolved. And you need somebody to come up and do that. And I will just, I have a student who's currently working on her paper, which is I can't wait to find her draft on Monday, where she is going to analyze. She has a day job working for the World Bank, and the World Bank has recently announced that they're going to allow loaning money to nuclear projects. And so her paper is, how do we have people who are thinking of democratic values compete with, say, Russia? And that's what her paper is. I can't wait to see what she's come up with, because I will tell you that there is one entity that has accepted nuclear power, warts and all, and they speak Russian. Okay, with that. Your choice.
Yeah. I won't. Okay. So today I will be covering the recent Supreme Court case that came out over this summer, the NRC v. Texas, and just give a little status update on interim storage of spent nuclear fuel. So I have a roadmap because that's what I've seen. Closer. Okay. So I'm going to talk about interim storage of spent nuclear fuel first. Then we're going to go into consolidated interim storage facilities. I'm going to call those SIFs, even though it sounds like CISFs, because I don't want to spit on the microphone. Talk about the Supreme Court litigation, which ended up settling out over the procedural issue, and it never reached the merits. And then talk about kind of the status in Wyoming and how to get involved in these sorts of waste storage facilities and those siting processes. So we've already talked about what spent nuclear fuel is, but just really briefly, it's a high-level radioactive waste composed of irradiated or used uranium or plutonium fuel that can no longer efficiently produce electricity. It has these three constituent materials, which are special nuclear material, byproduct material, and source material. So for interim storage, how that's defined is the temporary storage of SNF, typically at or near the land surface, pending the availability of a long-term disposal option. It is essential for nuclear energy production because the heat and radioactivity emitted by SNF make it initially unsafe to handle or transport when it's initially removed from the reactor. So SNF must be put into interim storage so that it can radioactively decay and cool enough so it can be transferred off-site eventually, which has not happened yet because currently all SNF in the US is being stored at reactor sites because no alternatives to on-site storage have been developed and the federal government never built a permanent repository. And I have in my notes that was a whole can of worms, but basically what to know about the permanent repository at Yucca is that those proceedings are paused and in limbo for the foreseeable future. And then the last time I checked, there were close to 100,000 metric tons of SNF that have accumulated at these reactor sites all over the US. And then for, there's these different ways that SNF is put in interim storage. There are initially, when it's removed from the reactor, SNF is put in spent fuel pools where it cools and is shields from radiation. And then when those pools fill up, those older and cooler units of SNF get transferred into dry cask storage, which you can see on the slides. So the type of interim storage facility that was at issue in this most recent litigation is a consolidated interim storage facility, so a SIF. This is a licensed away from reactor facility that provides dry storage for SNF from multiple reactor sites until it can be moved into a permanent repository. There's a couple of pros and cons to kind of adding this sort of facility into the United States' SNF waste management system. A SIF would consolidate and centralize the SNF backlog. It's an alternative, and I really like this quote, to the continued, unintended, and unplanned growth of an ad hoc, decentralized, long-term storage system at reactor sites by default. It would free up decommissioned reactor sites for other uses, and it adds flexibility to infrastructure to the United States' SNF waste management system. Some cons to these facilities are they are still only an interim solution. This could cause an increase in transport of SNF in the US. They could potentially limit or jeopardize nearby land use. They threaten to become de facto permanent disposal facilities, just like what's happening at nuclear reactors. And then they're also fraught with political and legal challenges from nobody wants these storage facilities in their state. It's a not in my backyard problem. So there's two issues before the Supreme Court, and the circumstances leading up to this litigation began when the NRC received two separate applications from private parties to develop SIFs, a SIF in Texas and New Mexico. Different parties are not related to each other. The NRC ultimately granted these licenses. However, the concerns over the cons of SIFs that I had in the last slide led to opposition in the two states where these facilities were proposed. The controversy over these two licenses has spurred multiple cases, United Strange Bedfellows against the NRC, including environmental groups, the state of Texas, and an oil and gas extraction organization, all kind of united together against the NRC. And litigation associated with these two licenses has been heard in the 5th, 10th, and DC circuits before it made it to the Supreme Court. So there's a lot of procedural history. I'm going to try to skip over most of it and focus mainly on what the Supreme Court has clarified going forward. So these two issues before the Supreme Court are who is eligible to challenge an NRC license in federal court under the Hobbs Act. Part of that is how does one become a party in NRC licensing proceedings. And then the second issue on the merits that the Supreme Court did not reach is whether the NRC has authority to license these sort of facilities at all. So with the Hobbs Act, it does not only apply to NRC actions and orders, it gives federal courts of appeal exclusive jurisdiction over several final agency actions, including NRC licenses, and allows any party aggrieved, is the language, by a final order to petition for judicial review under the act. And then the Supreme Court kind of clarified how one qualifies as a party aggrieved or an aggrieved party. The court determined that since this requirement applies to multiple agency final actions and is different from the Administrative Procedure Act aggrieved person standard, one must be a party before the agency. And a quote from the case was, "What suffices for a party in one category of proceedings may be inadequate in another." So what qualifies somebody for Hobbs Act review depends on the specific final agency action the petitioner wants reviewed by the Court of Appeals. The third row down there are examples of who is eligible or what actions make somebody eligible for Hobbs Act review. For the NRC licensing, those that can get Hobbs Act review are the applicant, a successful intervener in the underlying licensing proceeding, and an unsuccessful intervener. Then the bar is considerably lower for other agency actions like rulemaking. You need to submit a comment and then you would be considered a party under the Hobbs Act in the rulemaking process. And then I gave just kind of a random example of a different agency action that applies to the Hobbs Act with the FCC. But back to the NRC, there's an interesting intersection between what is a party under the Hobbs Act and what is a party under the Administrative Procedure Act, because the not Administrative Procedure Act, the Atomic Energy Act. And the Atomic Energy Act is what controls who is a party before the agency. Because only parties under the Atomic Energy Act can to actually challenge the final licensing decision. So that's why I put some stars. So who can challenge these decisions? A party, so an applicant or somebody who successfully intervened. With your unsuccessful intervener, you can get Hobbs Act review of the NRC order denying your petition to intervene. The court said that this addresses concerns that the NRC can gatekeep who becomes a party and can challenge their ultimate licensing decisions. Lastly, the court was split, there was a circuit split over whether someone alleging an agency acted ultra vires or beyond its delegated authority could challenge the agency without qualifying as a party aggrieved. So is there a different route besides Hobbs Act where somebody can challenge the NRC's licensing decision? And the big picture here is the Supreme Court said, no, the Hobbs Act is the only route to obtain judicial review because it does not specifically prohibit SIFs and provides a meaningful and adequate opportunity for judicial review. Because of those, including the unsuccessful intervener can also go and get Hobbs Act review of that decision. So then the next thing is, what is a party? These were supposed to come out in different orders. So I was supposed to throw that one image up at the end, but I'll just go over what's over there. To qualify as a party under the Atomic Energy Act, an aspiring intervener must meet several specific criteria. They have to establish injury in fact, causation, and redressability, so their administrative standing. They need to have an interest that may be affected by the proceeding and how the courts have determined that is a factor test and that analyzes the nature of a petitioner's property, financial, or other interest in the proceeding and the possible outcome of the NRC's order on that interest. They also use proximity to the facility rule often. The NRC often presumes that a petitioner has standing if they reside within approximately 50 miles of a facility, because the presumption rests on a finding that a person living within 50 miles may face a realistic threat of harm if there's any sort of release. Then you must provide one admissible contention, and that's what I threw up the kind of a snapshot of what are admissible contentions in the NRC's regulations. So these might require, for people who want to intervene, legal advice, legal counsel, technical advisors to make sure that your contentions are admissible. And you have to raise a genuine dispute on a material fact of, or a material issue of law or fact. So material means that you have to raise an issue that's material to the findings the NRC must make to support the licensing proceeding. So it's got to be material to whether the applicant has shown it can safely operate the facility or not. And then, so challengers to the NRC license lost because they did not attempt to intervene in the proceeding, or they did not succeed in intervening. So the court never reached the interpreting the Atomic Energy Act and the Nuclear Waste Policy Act to determine if the NRC has this licensing authority at all. The statute is kind of open-ended, and it has many areas of ambiguity because the NRC has historically had a lot of leeway in writing its own regulations just from broad statutes, because it says independent agency with specialized technical expertise in nuclear safety. And the Supreme Court did not settle the merits of this case, but they did provide some dicta where the majority opinion said that the history and precedent offer significant support for the NRC's longstanding interpretation that they can license these off-site private interim storage facilities. The dissent does not think so, and neither does the Fifth Circuit. But again, it is all dicta because they never officially reached that issue. So what does this mean for such a facility in Wyoming? And to kind of emphasize what Tara said, there are no proposals for this in Wyoming. And it's also currently prohibited under Wyoming law. Wyoming law currently prohibits interim storage facilities located off-site from reactors until the federal government establishes a permanent repository, and it also prohibits storing nuclear waste generated from out of state. But I did want to put up that the 10th Circuit agrees with the Supreme Court majority on the merits issue that the NRC does have the requisite authority to license these facilities. And then I'm probably going to have a lot of graphics over. Yep. Okay. That's okay. So how to get involved if at the NRC with these sorts of licensing interim storage facilities, consolidated interim storage facility or otherwise. One of the points I want to emphasize is that the NRC is not a siting agency. It doesn't really determine the location for these, especially private reactors. And the NRC enjoys exclusive jurisdiction over whether an applicant's SIF design complies with all technical requirements related to nuclear safety. Applications for any sort of like waste facility license in Wyoming would trigger the NRC's notice and public participation obligations. So the NRC would put notice in the federal registrar of these applications. And then the public can participate without becoming a party in several ways. They can observe and attend NRC public meetings. The NRC also must provide an opportunity to petition to intervene and request a contested hearing. That would make somebody a party, but the public has the opportunity to observe those meetings. And then the most opportunities, besides for intervening in the licensing proceeding, to kind of publicly participate in these processes is through the NEPA process, where in the NEPA scoping process, when they decide kind of the scope of their environmental analyses, they are required to invite participation from petitioners to intervene and anybody who successfully intervened, you can directly request to participate in scoping, and any affected state, tribe, or local agencies. Members of the public can also comment on their draft report before a final report is published, and the NRC is required to address each of these comments. And as a last note, because this was an issue in some of the underlying litigation, a state submitting a comment to the NRC on their draft environmental impact statement does not give you party status to the litigation. You have to intervene. Wrong way, I think. Okay. So then my last slide is how to get involved at any state and local, at the state and local level for any sort of interim storage facility for waste. And so states have the power to promulgate siting regulations. So the NRC is not the siting authority, states can be. So states may pass laws, but the Supremacy Clause prohibits states from passing laws related to nuclear safety. States may impose other conditions for non-safety motivated reasons, like you need to develop the permanent repository before we accept these facilities, et cetera. And then local governments can also influence siting of large industrial facilities through the enactment of local land use plans. And if I would look at your specific county government, if there's a project being proposed about those sorts of things. And sorry, my slides are all messed up. The must apply. Oh, and there's a little bit of confusion about this issue. I've asked some regulators and we haven't gotten a response back, but anybody who wants to have an interim storage waste facility, they have to apply to the Wyoming Department of Environmental Quality to site it. And it may need a permit from the Industrial Siting Council. We're not completely clear on that point, but regardless, there will be a report prepared on the environmental, social, and economic impacts of such a facility, and the WDEQ must provide an opportunity for the public to review the report and submit comments. And then the last point that I wanted to highlight, that an NRC license does not mean that a SIF will be built. That's definitely what has happened with the underlying litigation. The SIF proposed in New Mexico, even though they kind of won at the Supreme Court, they have decided to just drop the project and not move forward with it. So SIF developers must still comply with state siting laws and local land use plans. And that's it. All right.
Thank you so much for our panelists. And these are just such informative panels. I really appreciate it. And synthesizing some of what I've heard is that the industry is not waiting for this problem to be solved to move forward. And this means that there's this volume of spent nuclear fuel that's going to be accumulating both at DOW and DOE facilities, as well as at commercial facilities. And so this brings us sort of to an intractable feeling place. And I'm typically an optimist, although I read this week that optimism comes from the idea that when you look around you, you would think that the world is optimally created. So whatever the present state is the optimal state. That doesn't seem to be the case with this problem. So I guess looking forward, do you see a pathway? But to me, it seems that laws like Wyoming's that prohibit away from reactor storage for waste would also preclude siting of a reprocessing facility, since there'd be remaining high-level waste after reprocessing that then could not be stored there. Do you see a path, and how are you advising clients, both project developers and communities, on moving forward, given that the what then question of spent nuclear fuel hasn't yet been resolved?
Yeah, the question has not been resolved. And like I said, for a lawyer, it's easy to see why it's not resolved. We have a split government, and unless either one side gives up or they get together and agree on doing something, preferably enacted by a law passed by Congress and signed by the president or the other methods. Just having the executive sign something is not a law. It's just an executive order. But sorry for that little continuing legal education part. But yeah, I mean, you need, unless we're happy with having people who speak Russian solve the problem for us, we need to have somebody step forward and want to solve all of the problems, not pick and choose. If you only want to participate in a little part of it, the history has been over time, you will watch, like Connecticut, your nuclear dreams unzip. You've started to see that this week, and it will only continue. So I'm not telling you to change the law. I'm just saying that that's the consequence if you don't adopt it. So the path forward, there are a number of path forwards that can be done. One is to go under the needful buildings clause of the Constitution, which is infrequently invoked, but you could go under that and the state can waive its sovereignty and allow the federal government to build a needful building, which might involve spent fuel and processing it and storing it. And that's one possible vehicle. The other possible vehicle is to follow through on the same way that you license transmission systems in the United States, where you have a combination between FERC authority and state local authorities, and you get to do the zoning and all those other wonderful things. And they all work together somewhat slowly, but they all work together eventually to build the needed transmission lines that are important. The Low-Level Radioactive Waste Policy Act is another Policy Amendments Act, is another solution. And under those, there are individual compact acts that have been enacted by Congress where regions have come together and said, this is the way we want to handle our low-level radioactive waste. It's very important for us to handle it because we like giving people nuclear medicine. We seem to think that it helps save our citizens, and we like doing that. And this is the process by which we're going to deal with the waste that comes from that. That then gets enacted under the Policy Act, that then gets enacted into various regional compacts. Those are all paths forward that you can go either way. You can either go back to the executive, the federal government, and maybe even just take the legislature out of it and just go give it all the authority to the federal government or a federal executive. Or you can do it cooperatively, which is, I guess, traditionally the way we've done that ever since we wrote that nasty letter to the King of England in 1776 and declared our independence. So there are paths forward, but what is needed is a will to say, I want to solve all of it. It's sort of, it's a 100-year commitment. If we take the analogy to family law, the commitment is for better or for worse, not for only on paydays when you're getting paid, not when the mortgage is due. So from that analogy, I think the point is that if you want to be the center for providing the solutions, you've got to be the center for all of it. And if you only want to be, work on the parts that are somebody else's solving, you can do that. But as we found, for example, when you went to go for HALEU, the only people supplying commercial levels of HALEU spoke Russian. So.
That's high-assay, low-enriched uranium, for those of you who don't want to speak an acronym. I'm going to be a little more optimistic. I do think that it's a problem. It's not, volumetrically, it's not a huge problem. Like in the industry, we like to joke that you could stack all the casks of the spent nuclear fuel stored at the utilities and cover War Memorial Stadium's field 2 or 3 layers deep. It's not that big, relatively speaking, but it's visible. And I think this is one of the fundamental things that the nuclear industry has that differs from fossil and from the renewables. Well, we'll talk about, we'll do another panel for wind power blades. It's very much omnipresent. Like you look at the spent nuclear fuel, it sits in a cask. It is the burned up remains of the power. So what do you do with it? Now there are, and I can tell you this in industry, there are people looking at recycling, maybe not what we thought about in the 1970s and 80s, but thinking about it in terms of medical isotope extraction. For those who don't know, radiological medicine is really transformative. It has saved many people from thyroid and breast cancer. We regularly irradiate cobalt targets at the Idaho National Laboratory to create gamma knives. It is something that we do, and it's hugely valuable. So there are companies that are actively looking at that as a business line, taking the waste and thinking about it not as an externality that we need to just throw away into Yucca Mountain or a deep borehole, but what can I extract out of this? Looking at critical minerals, another potential source, and that's true for coal waste as well. So I think there is some traction there. And for what we didn't talk about, although it's important to note, we operated from basically the advent, every reactor that operates presently operates on low enriched uranium. This is 5% and U-235, don't worry about it. But HALEU, high assay low enriched uranium, which is what all these advanced reactors use, they're gonna operate at a much higher percentage of uranium concentration in their fuel. For those types that can be reprocessed, you can make it so that you can extract some usable uranium in that reprocessing and make more fuel. This is always, the physicists love to talk about it. They love the idea of the closed fuel cycle, as Bud and I have talked to them over the years. And if they can make it work, it's great. Because right now, for these advanced reactors, we don't have enough enrichment capacity in this country. And the only place in the open market that does is in Russia. So recycling of higher enriched material to make HALEU is necessary, because we're not going to be able to build any of the 20 reactors that I talked about and power them in any meaningful way without significant intervention, and recycling is part of the answer there.
Yeah, if I could just add to that, I think the people in Wyoming who have been supplying coal and oil and gas realize that any of these power facilities we're talking about without the fuel is just very interesting furniture.
Yeah.
I think before I open it up to everyone here for comments, could you give us an idea of timing? What is sort of, we clearly know with our existing commercially operating reactors that fuel is accumulating now. But in terms of the timing that it would take to potentially develop reprocessing capacity, the timing at which existing supplies of HALEU would be depleted and we would need to have those resources available, and the timing when we would expect these new unique forms of spent nuclear fuel from advanced reactors to be ready for or needing reprocessing or storage. So what are we thinking about when we're trying to orient our minds temporally around this issue?
So I'll start off on that one. The reactors themselves, the executive orders, which do not have the binding force of law, they are calling for operations by July 4th of next year. That is optimistic in the extreme. Nuclear reactors, for those of you who tracked Vogel, took 10, 15 years to build those?
20.
20, yeah.
Who's counting?
Who's counting? If so, a more realistic for some of these smaller entities, and some of them are looking at like the 1-2 megawatt scale, you may be able, I think if I was a betting man, probably 3 to 5 years you could get there if they can secure fuel. If we simplify NEPA to the prior speaker's points, to the point where we're using categorical exclusions or environmental assessments instead, and if you can secure skilled labor to build them, which is a topic for its own panel. So that's 3 to 5 years for construction and then to operation. And then because you're using in most cases a high assay low enriched uranium, you have a longer burn on the fuel. So the fuel can, in a normal reactor, cycles through every 18 months. That's at 3 to 5% enriched. For what I am hearing from industry, some of them are thinking that they'll be able to go out 5 to 10, maybe optimistic. We really don't know, because we haven't built these things in Fort St. Vrain in Colorado, closed in the late 80s or early 80s, late 70s, as the last non-white light water reactor we operated. So I think all said, if everything works in the most optimistic sense, you've got 6 years to really figure it out. For TRISO fueled reactors, we're not going to reprocess. That's a Manhattan project level build of infrastructure to do. You're just going to dispose. For Sodium bonded fuel, for those of you who remember high school chemistry, don't mix sodium in water or air. So, and especially if it's bonded to uranium, bad things happen. So you've got to create inert environments to treat, as we have at the Idaho National Laboratory. If we're doing that at scale, we need build, because we don't have infrastructure in this country, government or private, to manage. Yeah, Bud, what do you?
I will just, I mean, optimistically, on terms of the time it takes to build a totally new concept, you can go back to the end of the 1940s when Captain Hyman Rickover thought it would be a good idea to put nuclear power on submarines, and that would be a significant warfighting advantage. And I will say, from the current Department of War, remarks made earlier this week, Jeff Waxman, what came from being able to go from a concept in 47 to a prototype in Idaho to a reactor steaming around the ocean by 53 within 5 years, that's multiple reactors, is the fact that there was about 14 designs being worked on. And so, like Jeff Waxman said, build 8, build 9. Not all of them are going to work, but if you don't build any, you can't wait until you know which one is going to work to do it. And yeah, so if we're going to sit around and conduct paper studies about paper reactors, and I have the quote from Admiral Rickover, if somebody sends me an email, I'll send you back Admiral Rickover's quote about paper reactors, which he gave to Congress. If that's what you want to do, is do paper studies, then you can have paper reactors. If you want to have real reactors, you have to bend metal, you have to embrace the possibility that it's going to be hard and difficult and a challenge to make the industry work. And then you're going to have to work through those challenges, which are going to require a lot of very smart young minds. Right, Scarlett?
So I think we have 3 minutes left.
Do we have any questions? I have more questions, but I want to give you guys an opportunity, and then knowing that we're also going into lunch and you'll be able to make sure that our panelists don't have time to eat a bite. Jacob? do you
I
have a
will
mic?
just say, while we're waiting for the question, that here I am arguing that there is no free lunch in building nuclear power plants, and somebody is offering you a free lunch. I just feel like I've been undermined.
Yeah, along with the Nuclear Waste Policy Act of 1982 that established a repository, they created the Nuclear Waste Fund, which collected about 1/10 of a cent from every kilowatt hour produced by nuclear power reactors. They did that from 1983 to about 2014. Yucca Mountain was supposed to open in '99. They sued the government. The last I saw, the government's accountability offices said it's like $47 billion in that nuclear waste fund. If they were to restart it now, that'd be like $785 million a year more into that fund. So why aren't we utilizing that fund? Why aren't we have this huge war chest?
Oh, well, that's an easy answer. There's a law passed by Congress that says that all of the proceeds from the Nuclear Waste Trust Fund will be used to buy U.S. bonds. And so it does. And it continues to go up in value as it continues to buy U.S. bonds. So unless Congress changes the law, that's what's going to happen to the money from the trust fund. I agree with you. It would be nice to do something else with it. Certainly that's the industry position. But right now, there's an easy answer. Congress has told you what to do with the proceeds of the fund. Buy bonds. And it's a good strategy. I wholly endorse buying U.S. bonds. I'm certainly not criticizing it. Yeah, go.
Yeah, so I had a question about those in Congress now. Is there anybody leading the conversations about nuclear reform that we should be paying attention to?
Senator Risch from Idaho is certainly a strong advocate for a number of things that he wants to see to go make this a better process. I think Senator Booker from New Jersey also has some deep thoughts. Senator Coons from Delaware used to. I don't know if anybody's taken over from his perspective. But there are certainly leading lights in the Senate on both sides. It is a much greater challenge to find, and Senator Barrasso is also, I would add that. And so you can find people in the Senate. I think it's a much greater challenge after Representative Shimkus from Illinois, a former Marine. Is our Marine still here from the mining organization? A former Marine. After he left, it's hard to find somebody who's quite the advocate in there. But there are a couple of representatives from California that are part of the Spent Fuel Solutions Conference and want to solve the fuel part, but are not necessarily fully embracing the idea of having a nuclear renaissance.
I will jump in before Temple cuts me off. The one other thing I will add, this is a surprisingly for Congress, and I live in Northern Virginia, go to DC, and it's a weird time. This is an area where they tend to get along and agree. There are a few outstanding voices that are loud and oppose all things nuclear. Oftentimes they represent districts where there was waste that was orphaned by the AEA, that's typically, or AEC, that's typically that population. But I have seen over 10 years, and honestly, it has been really since the end of the Obama administration through Trump 1 and Biden, bipartisan support. This is not a partisan, nuclear development isn't partisan. Yucca Mountain is because Nevada is a swing state, and until that changes, nobody's gonna want to reopen it. That's just the electoral map. And it's unfortunate because it harms us all.
And I will just add that spent fuel doesn't vote. Even in Nevada, I mean, I know people might think so, but it doesn't vote. And I mean that both metaphorically and physically. But metaphorically, the last poll I saw in Nevada said that it's like, it makes the top 5, but it makes it as number 5 for most, on the minds of most voters. There are other issues that are higher than that. And so the answer is that this is an economic question. This is a policy question. Do we want to cede this space to people who speak Mandarin and Russian, or do we want to dominate in this space because we think it's good to do it? And if we think it's good to do it, we need to embrace it, warts and all. Or at least somebody who speaks English needs to.
Well, great. Thank you for a wonderful panel. That was really fun and informative. So thank you. All right, we're gonna break for lunch, and thank you to Wellburn, Sullivan, Meck, and Tooley. I see Danielle DeMoro's over here. Thank you, Danielle, for the sponsorship for lunch.